I'm going to talk on this expert opinion, the admissibility, evidentiary value, and the practice in usual in our country. And the learning objectives for this presentation today would be: what is exactly an expert opinion as per law? What is the admissibility of expert opinion as per law? The evidentiary value of expert opinion, and then there was a study that we conducted on about 70 cases. I'm going to talk about it in relation to especially expert opinion. So, as far as the admissibility of expert opinion is concerned, expert opinion as such is not, defined by law, but expert evidence is. And expert evidence is described in Section 45 to 51 of the Indian Evidence Act. The new one that is going to be rolled out from 1st July will be called BSA, or Bharatiya Sakshya Adhiniyam. That will be replacing the Indian Evidence Act. But all the laws that are there, 45 to 51, they have been retained in BSA as well, with minor things here and there, but it would remain in effect as such. The general rule of law is that the opinion of expert is not admissible as evidence. Now, the very obvious question arises: if it is not admissible as evidence, then why at all are we talking about it? Well, it is not as simple as a statement that it is not admissible totally, but that is the basic working rule of all the courts, that it is not admissible. But yes, the law also says that yes, it is admissible. So the law of relating to expert evidence has come a long way since since there have been so many court judgments in relation to this, what we call as law of precedents. So as per law of precedents, expert evidence is yes admissible as evidence, but what are the circumstances, what are the limitation, and what is the power of the courts is what I'm going to talk about over here now, as far as expert opinion is concerned. So, talking about evidence, there is something called as evidence evidence act, and there is Indian Penal Code, and there is Criminal Procedure Code. These are very, very basic for our understanding of what we practice in medical law and whatever applies to us doctors. Now, in the Evidence Act, there is expert opinion, which I said does not actually is not actually defined by any law, but evidence is defined by law very much. So, and who is an expert is also defined by law very much. So, the law says that Evidence Act does not apply to the consumer courts. Now, whatever we are discussing applies mostly to the consumer courts. Whenever there is a litigation and a case against the doctors, it is taken up by the complainant goes to a consumer court, is taken up by the consumer court, and we have to defend it by giving a written statement and blah blah. So, whenever a case goes to a court, whether a consumer court or a civil court or a criminal court, now there are, sections in law to govern each of these. For offenses, there is Indian Penal Code. For punishments to offenses, I'm talking at a very, very basic level. These are not like, absolutely, defining words, but at a very basic level, all the offenses are described by the Indian Evidence Act. All the punishments relating to those offenses are defined by the Criminal Procedure Code, although this is not a complete statement itself, but and all the, how the evidence is taken up in a court of law, very, very basically saying it is defined by the Indian Evidence Act, Bharatiya Sakshya Adhiniyam, the new one that is. So the in civil courts or in criminal courts, the Evidence Act applies properly, in the strict sense. The second part of this, the second para in the slides, you would say, the courts have decided in many judgments, Molecular Gamli versus Sukumar Mukherjee and IMA versus VP Shanta, that the Strict Evidence Act would not apply in in the consumer courts. But does that mean Lenient Evidence Act would apply? Yes. So there are some parts of the Evidence Act which apply to consumer courts, and this is statements I'm talking about this. Why? Because there are many things that we are not trained in law, we do not know much about law, so we think that okay, this is a general reference I have, so I'm going to show this in front of the court, that see, Judge Saab, this says that whatever I did was right. So law does not work like that. Okay. Or I would ask the opposite side, the complainant in the court, or I would ask the expert that the complainant had to produce in his favor, that whatever I did was wrong. So I'll cross question him. So I cannot cross question him because that part is not allowed in a consumer court. So just to complete this question that I have raised, so what happens actually is that whenever there is a question of cross questioning the expert that has been produced by the complainant, or cross questioning of the expert that has been produced by me, the defendant doctor, in the court by the complainant or the complainant's advocate. So how it works is that the court says that I will not allow cross question. They can allow cross questioning, but it is done very, very rarely. So what happens practically is they say you give a list of questions, and that is supplied to the opposite party, and then the expert or whosoever, they will frame answers and give in the form of a affidavit to the court. So the consumer court's proceedings are decided summarily. Okay, they are not bound by the strict Evidence Act. The powers of a civil court are very much there with a consumer court. That is the power of summoning witnesses, collecting evidence, documentation of evidence, and all these things. But all the detailed Evidence Act does not apply to consumer courts. And when we say that the cases are decided summarily in consumer court, it means that all these detailed courtroom procedures, as we might have learned in MBBS during forensic, or we know that okay कि पहले oath होती है, फिर chief examination होता है, फिर cross examination होता है, फिर questions by the judge होता है, re-cross examination हो सकता है, re-examination हो सकता है, फिर questions by the judge, and then finally judgment is pronounced. It might sound very simple, but all these procedures are not followed in detail in the consumer courts. Now, this is the importance, because the importance is that we have to, give everything in writing to the court, and the court does give a final date for argument, and that is the only hearing purportedly by the court to listen to both the sides, and the court then makes up the mind, okay, how much compensation should be, whether doctor is negligent or not, and all these things. So moving ahead, who is an expert as defined by law? So expert opinion as such, as I said, is not defined by the Indian law, but who is an expert is defined under Section 45 of the Indian Evidence Act, or VSA 1872. So it says that opinion of experts, when the court has to form, this is the exact legal language, when the court has to form an opinion upon a point of foreign law or science or art, or as to the identity of handwriting, the opinions upon that point of persons especially skilled in such foreign law, science or art are relevant facts. Such persons are called experts. Okay. So, there's a very fundamental thing that I want to, highlight over here. We tend to call ourselves experts. Okay. I'm a forensic medicine expert. So, what is the correct term? What is the difference between specialist and expert? So, as far as medical council is concerned, we are all specialists. We are not experts. Expert is a person, to claim an expert is like, you know everything about everything. But as far as the law is concerned, the opinion of expert or who is an expert is, okay, 45 Indian Evidence Act. So it would be proper and very, humble to call ourselves, okay, I'm a gynecologist. I'm a specialist in gynecology and obstetrics. I'm a specialist in pediatrics. But not that I'm an expert. Calling an expert is like, it's not very, my personal opinion, not very proper. But legally speaking, okay, 45 Evidence Act, and where do our medical doctors, we are covered in the part of science and art, as far as Section 45 of the Indian Evidence Act is concerned. So if an expert is giving an opinion, it is considered as a relevant fact for the case. And an expert is, because an expert is devoted his time in learning a special branch of expertise, and thus is specially skilled in the subject. It can include superior knowledge and or experience. What is the significance of this statement? Court में अक्सर ऐसा होता है when an expert is called, even let us say the defendant doctor is sometime, the argument stage पे the judge साहब is asking that okay, जो consumer में president है, member है, they are asking not necessarily a judge but yes a judicial officer, कि डॉक्टर साहब आपने ये बताया, okay, let us say a very practical example, you are palpating the abdomen of a pregnant woman, you are not measuring exactly by a ruler, okay, how many inches or centimeters it is above the pubic symphysis to call it, okay, this is X weeks of in pregnancy. You just measure by your, hands, by palpation, by your experience. So when we say experience, you say, okay, this is my practical experience. If the court asks, did you measure it with a ruler? You can confidently say, no, there was no requirement. It is based on my experience and knowledge. And what is that knowledge? Your qualification and whatever textbooks that you are referring, or if there is a statement on affidavit that you have produced in the court, then that authority or the reference behind it, the court uses the term authorities, instead of references. They are very fond of this. It's kind of a legal term that they use. So the general rule is, as I shared earlier, that the opinion of experts is not admissible as evidence, but the report given by an expert is relevant and admissible in a consumer court. So, however, the opinion might not be admissible. It does not mean that the evidence that in the form of the report that is given out by the specialist doctor is not relevant. It is admissible in a consumer court, very much it is, but the opinion upon it is not necessarily accepted by the judicial officer, by the court. But when is it accepted? I'm coming to that. So, and why is that the opinion is not accepted by the courts? One important reason is the cases of res ipsa loquitur, when we say the thing speaks in itself. That is, if a court, for example, finds a scissor inside an abdomen which has been not documented in the case records, was amounting to negligence. So the court says that I don't need any expert's evidence. It is very clear to me that it was negligence. This is one example, but there are many examples. The court has the power, not only the power, but it is actually, if we give it a blanket statement that every opinion given by an expert, the experts can be bought, both by the defendant and both by the complainant. So this is another big reason that the opinion expert is not admissible and should not be admissible in a court of law. It's by logic that the evidence of an expert should be explained to the court in detail. I'll give you another example. If any oral evidence contradicts the data or the report that is there already in the complaint or in the defense of the doctor in the court in the form of affidavit, then it will not make the evidence invalid. So the evidence is there, it does not become invalid by a contradictory opinion of the expert. But the fact that there is a contradiction to the opinion of the expert, then this fact or that report, it becomes relevant or important. Now, what is the meaning of this? For example, we had two cases very recently. One was in Delhi. We were discussing with a gynecologist, and another was a couple of months ago outside Delhi. So both had similar kind of finding, where in the postmortem report, a tear was mentioned, okay, in the uterine artery or one of its branches. I don't know. So, but the only word tear was mentioned, okay, and the amount of the word in one case was written as hemorrhagic fluid. Now, our defense, what could be our defense as a doctor? Very simple. Now, the tear, I'm going to ask you, what is a tear? The specialist who has said, the expert, we'll produce an expert, okay, and we are going to ask the postmortem doctor or the complainant that what was the size of the tear? Was it mentioned? One. Secondly, what kind of injury is a tear? Is it an abrasion, bruise, lacerated wound, incised wound, okay, or a chop wound? Whatever he's going to say, okay, it is a lacerated wound. Okay, if it is a lacerated wound, was it small in size, big in size? If the size is not mentioned, then he'll say approximately. It might contradict if it is not written. The details about it are not mentioned in the postmortem report. Then fourth question is, how did you see it was a tear and not an incise wound? It could have been a surgical wound. Okay. Uh, the doctor is going to say, okay, I watched, examined with a naked eye. Can you examine such a tear with naked eye, or did you use a magnifying glass? Okay. How many dimensions does a tear have? Length, breadth, depth. Have you written them? No. Have you written the size of all of these? No. Then, okay, how much was it away from so and so soft tissue or hard tissue landmark? Okay, so there could be so many things, and these are the practical defending points that I'm talking about for that particular case. So whenever the expert opinion is in contradiction to a fact already mentioned in a report that is produced in the court, then the when relevant does not mean that it is nullified or it becomes exaggerated. It simply means that it becomes important for the court to see that something is amiss somewhere, and the doctor should be given benefit of doubt, or maybe the it is fictitious that the finding is mentioned in the report, or it should not be, it does not have any importance, and we could have a number of arguments regarding this. And that is why the legal opinion, because see, producing an expert simply does not mean that, okay, one, I won the case or everything is in my favor. But yes, it would definitely tilt the case in your favor, because that is your, with logic and with authority, the references that you have provided to produce your, because expert opinion should always be supported by solid textbook references. When we say textbooks, Indian or foreign, the court would go for Indian textbooks first and later foreign textbooks. And we are always ready with, as I said, journal references, journal articles. So journal articles come after textbook references. I'm sorry. Then again, Indian journal articles would have more weightage over foreign journal articles to support our statement as an expert. So that is the value of an expert opinion. That whenever anything that you are giving and you are producing an expert in your favor, for example, the Foxy is doing it, every statement should be supported by a solid reference. That is one. And if you are contradicting anything, then you should again have solid logic. I always, whenever I contradict any finding in the report, then I make sure that I give at least 3, 4, or 5 solid reasons to prove myself that why this finding is disputable. Either it is fictitious, or it is not correct, or it is not matching with other things, or that complaint that the patient is making is it is not a true fact. Okay. So among all the defenses that we have, among our legal armamentarium, I'm sorry to say, but this is a very clear fact, as a specialist, that most of us do not know. They think कि ठीक है जो we do not know how to answer simple questions. We say कि ठीक है जो हमने किया वो ठीक किया, okay, जरूर किया होगा. But if we keep answering everything the way we think that it should be answered, we are sure to lose the case. So we have to know कि because हमने देखना how does the court think for every complaint that the complainant is making, and the sufferer, the victim has suffered so much. So what has the doctor done to have proper or average, if not perfect, then average care or management of the case towards the patient. So that is, so we have to be legally sound enough. We are not legally sound enough to realize the value of these defenses and when to use which defense actually. So we conducted a small study of 70 cases decided by the Indian courts of law, medical negligence cases in both consumer and criminal courts within the past 1 year, with the search words medical negligence and expert opinion through websites using Canfonet, CaseMine, Indian Kanoon, using as Google as a search engine. And we found that in about 22 cases, medical negligence was decided by courts out of the 70 cases. And in 24 cases, a medical board of experts was empaneled to judge whether there was medical negligence or not. So almost 2/3 of cases were without a lawful medical board to comment on the question of medical negligence. 2/3 out of 70. If we were to, this is a very small number, 70. If we were to take all the cases that have been decided till date, I'm 100% confident this would go above 80, maybe 85% out of the total, which is, humongous gap between what we think that when we think that judgment should go in our favor and when it does not. So we found that expert opinion at the individual's level. I'm going to skip this one, not much data. But the average compensation awarded in these cases was about 9 lakhs out of 22 cases in which compensation was awarded. The highest compensation was just incidental finding, 1.6 crores, and lowest was 1 lakh out of the 22 cases in which compensation was granted. And in almost two-thirds cases, 70%, no compensation was awarded. Again, if I am going to include all the cases that have been decided till now, I am sure it would be in the range of around 85 to 90%. So in which no compensation was granted. But obviously, we are talking about cases in which compensation was granted to see where we did not perform our task perfectly or where we went wrong, so that we do not fall into litigation further, or we are able to defend ourselves better. So this was, although not significant, but we did found by another method that the odds of having no negligence when a board of experts was present was 66%. That is, the probability of having odds of no negligence increases if a board of experts is present. Now, this is a very significant finding, 66% for only 70 cases that we studied. And again, if there were more number of cases, I'm sure this odds of having no negligence would go much higher. These were some figures from my study, and what we found was that as per practice, it is more of a rule than an exception to not obtain an expert's opinion. That in this study, two-thirds of doctors, they did not obtain an expert opinion to support their defense in front of the court. But the decisions of the courts are a good step in this direction of making the law clearer in the area of evidentiary value of expert opinion. Why? Because there have been many cases in favor of doctors where no compensation was granted whatsoever, and doctors are not adjudged as negligent. And one important line, I mean, I can have many judgments that I can produce in front of you, where courts have categorically said that since the complainant has not produced any expert's opinion to substantiate his claim of negligence, hence the complaint is dismissed. So this is a very, very significant statement as far as expert opinion is concerned. Although, there are so many things to discuss, but I have narrowed my talk to the topic, only talking about expert opinion. There have been many cases like this, So that is the value. So this was a short and sweet talk. In conclusion, it cannot be said that this is a very significant statement. I would like you to go through it very, very, carefully. It cannot be said that expert opinion will successfully tilt the case in favor of the provider of it, whether the complainant or the defendant doctor or hospital. But it can confidently, as far as statistics go, in this particular study, 66% confidence, it can be stated that it will give an upper hand to the one using it in his favor in the court, especially if the opposite party does not. So there have been cases where the complainant had produced an expert in his favor, obviously a doctor who's been paid by the complainant to give evidence in his favor, and the defendant doctor has not produced, and the complainant has won the case. So it will definitely give an expert opinion. I mean, you have to take it for granted that whatever defense that I'm giving out, it has to be supported by an affidavit of a doctor, my specialty association, my Indian Medical Association branch, or IMA headquarter, or anybody. We cannot simply rely on our state medical council always. Yes, state medical council, it can go in our favor. Mostly, I'm not talking about the fact that the DMC is working in our favor or not. Okay, there are so many 30 state, 28 state medical council in the country. So we have to see our own, अपना घर पहले देखना है कि at least we are coming out with clean hands and confident, strong hands with the expert opinion in our favor. So yes, there is some lacuna in the law as far as expert opinion concerned, but law has come a long way, and I don't know these amendments, although they have not been mentioned in the BSA, Bharatiya Sakshi Adhiniyam, the new one that is going to roll out. But yes, there should be some amendments to take care of the weaknesses in the law as far as expert opinion is concerned. They should be given more weightage to the authority, the reliability, the position, the experience, the knowledge of a expert who is giving opinion in favor of, I am not saying only a doctor, maybe in favor of a patient, but the fact that, and then the expert opinion given by a board of doctors of a government hospital, for example. Or why only a government hospital? Why not some good corporate or academically sound private hospitals also, in consonance with the experts of government hospitals, to give out a opinion under section 45 of Indian Evidence Act. So this was my short and sweet message for today. If you have any questions, I'll be glad to take. Thank you so much.